All right, my watch says 6 o'clock, so we'll go ahead and get started without further ado. My name is Blake Bingham. I am the Assistant State Engineer over the Water Rights Adjudication Program for the Division of Water Rights. This is as you know, the public meeting for the Provo Canyon Subdivision of the Utah Lake Jordan River General Adjudication. We often will refer to it as Area 55, Book 9, or sometimes you'll just see abbreviated 55-9. Kind of the rules of engagement for tonight's meeting. As we kind of go throughout the meeting, feel free to raise your hand and ask questions. I'll try to answer them to the best of my abilities. If at any time you feel like your curiosity has been satisfied, feel free to stand up and make your way out. If you have questions that are maybe more specific to your own situation, ask to either hold off on those, or you can make your way out into the hallway, and some of my staff over here, Josh Zimmerman, I'll go ahead and introduce him. This is Josh Zimmerman. He's going to be the team leader that's responsible for this particular subdivision, and then Nick Yater is one of his staff. They'll be able to help you out in the hallway if you have a specific question during the course of the presentation. Otherwise, afterwards, you can hang out, and I'm happy to stick around and answer any questions as well. So let's go ahead and kick this thing off. Here's the agenda for tonight's presentation. Presentation usually runs about 45 minutes, depending on the number of questions and the level of back and forth between the audience and myself. If we're also streaming this on YouTube right now, as well as it's being recorded for later viewing for those of you who want to go back and review it. If you happen to be viewing remotely, if you have questions, you can email those questions to that email address in bold blue lettering at the bottom. At the conclusion of the presentation, I will read those questions for the benefit of the group and try to provide an answer to you. That email address will be shown again at the conclusion of the presentation. But this is also a good email address for anyone who wants to get a hold of me. This goes to my inbox. It's not my personal email address, but it forwards to me. But I really encourage you to use the team leader, Josh Zimmerman's email address, or just because he's going to be the guy that's going to be boots on the ground for this subdivision. So he'll be able to answer your specific questions to a greater degree. But I'm always happy to forward these forward or try to answer them myself as well. So the agenda, we're going to overview of what the adjudication is. We'll talk about what a proposed determination. That's going to be a word that a couple of words that you're going to hear a lot tonight. We'll describe what that is. We're going to talk about some of the significant issues and the timeline, and again, questions throughout this presentation. Please throw up your hand, and I'll do my best to repeat the question for the benefit of those online viewers and then answer it for the benefit of the group. All right, so usually when we do these presentations, I've done 20 or 30 of these now, we like to start off with kind of Water Rights 101 to help everyone get up onto the same sheet of music. I understand there's probably a broad level of experience with regard to water rights or even the water rights adjudication. But in kind of get everyone on the same foundation level, we'll talk about what is a water right, first of all right, and how it might differ from shares in a company. So first of all, a water right, what is it? Well, it's really the right to divert water from its natural source and place it to some type of beneficial use, okay? It typically has a couple, these characteristics. It has a nature of beneficial use. That's just, what is the water being used for? Is it being used for irrigation? Is it being used for stock watering, for domestic use, municipal use? And in Utah, the beneficial use is kind of what we key in on. By definition, water rights basis, measure, and limit is its beneficial use. So when we talk about how big a water right is, we typically don't talk about its volume or its flow rate. We talk about how many acres, how many domestic units, how many stock, because when we talk about water rights, it's the beneficial use that matters, okay? And we'll kind of circle back to that a little bit later as to why that's important. It has a priority date. A priority date is just a way of measuring who gets their water first. So in the arid West, we have less water than we have demand for, right? There's not enough water to satisfy all the demand for water. And so we have this system of priority, or sometimes it's called prior appropriation. And this is different from the east, which has where water and precipitation is abundant. We have a priority system where if you obtain a water right, if you appropriate a water right before your neighbors, you have a senior water right. So a priority date tells you where you are in line to other water rights with respect to, do you get your water first if the water supply diminishes. There's a defined quantity of water. We measure that in either cubic feet per second or acre foot per year. Sometimes that will be abbreviated in CFS, or an acre foot might be AF or ACFT. Again, those are just measurements we use to quantify the actual physical amount of water. We have a point of diversion, which is a fancy way of saying where the water is removed from its natural source. So if it's a well, the well is the point of diversion. If it's a spring, the spring box is the point of diversion. If it's an irrigation ditch off of the Provo River, it's where the diversion point is, where the head gate is for that ditch. Those are the points of diversion. And that's important because that's where we identify what rights we're looking at, is where the point of diversion is located with respect to the subdivision boundary. And then we have a specified place of beneficial use, and that's just where it's being put to use. And we use the public land survey system to kind of identify that. For those of you who are not familiar with it, just think of a big grid, Cartesian coordinate system for the state of Utah that tells us, where the location of a certain point is. Let's talk about what may provide you evidence that you have a water right. Often when we send these notices out, and I forgot to mention, when we send these notices out and they have summons in them, there's sometimes the impression that this meeting is mandatory, you are required to be here. That's not the case. The language of the summon is not very clear. Unfortunately, that's the statutory requirement for us to provide that to you. It is a legal proceeding, but I just want to make sure you guys know that you're not required to be here. You can leave anytime. You will want to participate if you do have a water right, but if you don't have a water right, no need to participate, or if you don't assert a claim to a water right. Usually when we send out these notices, a lot of the phone calls we get are, hey, I received this notice in the mail and this summons. How do I know if I have a water right? And that's pretty common. It's actually a lot more common in more urban areas. In more rural areas, maybe like in this subdivision, people are probably a little bit more familiar with the wells and the irrigation ditches because you're probably using them a lot more. In more urban areas, some of these wells have long since been abandoned and people don't understand what a water right is or what it looks like. But often what will manifest the existence of a water right is a wellhead or an irrigation ditch or some type of irrigation diversion structure that are located on your property. You can kind of see an example of a domestic well on the far left, a head gate for a ditch in the center, and then another well. And these are a lot of these types of wells are things that we've been dealing with as we've migrated down Salt Lake Valley and into the Provo area. But now as we kind of go up into the canyon, there are going to be a lot more surface water rights. And so you probably will mostly see things like that manifest themselves in surface diversions. So what a water right is not. Often people will use the term water right or water share interchangeably, and I can certainly understand and empathize with the confusion. But for the purposes of our discussion, and any time you interact with my staff, you'll want to be sure what you're talking about because they have distinct meanings. A water right is something that is tracked at the state level, okay? Whereas a share is a share in a company. Now that company has a water right to divert water. What they have typically done is they will appropriate water, a large amount of water, and then issue shares to shareholders. As far as the state is concerned, we are concerned with water rights. Shares are an important aspect of some of these water rights, but they're usually internal to the individual water company or organization. So you might have a share in a company, and that company owns the water rights that we interact with. So when you talk about water rights or water shares, just make sure you understand the difference between those, because they have different meaning. If you say, I want to file a claim on a share, our response might be, well, you don't need to file a claim on the share. Your company needs to file the claim on the water right. And so we just don't want to confuse those two. So just something to be aware of. Also, and again, this is probably not as applicable in this subdivision, your connection to your municipal water supplier is not a water right. That's just a service that they're providing you in return for payment. The municipality typically does own water rights, and then they provide that service. So just to erase any confusion there, simply because you get water from somewhere does not mean you have a water right. Again, I think the term right has been so broadly applied these days that everyone thinks they have a right to water, and this must be what this is talking about. And if they don't participate, we're going to shut off their municipal supply. No, it's a very specific meaning. So let's talk a little bit about what we're doing here. And really to do that, you're going to have to forgive me. I have to provide a little bit of historical context, because it shows the evolution of why we're doing what we're doing here and why we are finally getting to you guys, right? And that's one of the questions, is what's prompted this? Why are we now getting this? And I'm going to get there. But before I do that, I kind of need to kind of back up go in the Wayback Machine, right? And look at why we have water rights in the first place in the state of Utah. Well, as you all know, in July of 1847, an advance party of the Mormon pioneers entered the Salt Lake Valley. And right away, they started diverting waters from City Creek in order to soften up the ground so they could plant a late season crop. Of course, bad joke, they then built their shopping mall on top of that. That plays a lot better in the Salt Lake Valley, because the whole City Creek mall. But anyways, people in Moab have no idea what I'm talking about when I do that joke. All right. Well, about a year later, Brigham Young made the statement that, the waters from the canyons, they don't belong to anyone. They belong to everyone, in essence, all right? They belong to the people. And that has been a fundamental concept of Utah water law ever since, that the waters of the state are everyone's. They don't belong to the state. They're not owned by the state. Now, we attempt to administer them and ensure that the appropriation people are diverting according to their rights, but they're owned by us as a whole, right? So it's a public resource. Well, between the years 1847 and 1850, what we now know as the state of Utah went from being part of the country of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. But even though the name changed, or the architecture of the government changed, the concepts of diverting water remained the same. They're typically done on a communal basis, right? Brigham Young would probably send out some parties here and there, and the parties would establish a community, and the first thing they'd have to do in order to subsist is start diverting waters and irrigating, putting crops down so they could live. And so the diversion of these waters began on kind of a community basis to satisfy the immediate needs of the settlers. However, the doctrine of priority started to evolve when you had subsequent settlers come into those areas. Now, obviously, the first settlers who had done a lot of the work in digging the ditches, creating the diversion structures, felt like, hey, we should have the first right on this stream. And then you have this simultaneous event of the gold rush happening and mining claims. So you have kind of this meld of people coming in later, and this concept of priority or staking a claim with the gold rush built up the system of priority, where those who had put in the initial work had a primary right. Those who came later, they had a secondary right. So people who put in the work first, they got their water first, and people came next, got their water next. And this was actually a system that was used throughout the western United States, but originated pretty much here in the territory of Utah. So it's something that's kind of cool that Utah or the Mormon pioneers were kind of pioneers in the realm of irrigation, because not a lot of people had tried to brave actually taming this part of the West. Well, as you can imagine, with water in the arid West, conflicts arise. Well, the only real framework to resolve those conflicts in this initial era was through the LDS Church, or the Mormon Church. And so what would happen is you'd have neighbors arguing over their turns on the ditches, who got the water when, and then they'd take it to the local bishop, and the bishop would say, oh, this Farmer John, Brother John, you get the water, and you have to wait your turn. And if the other guy didn't like what he said, then he'd take it to the state high council, and the high council would kind of act as an appellate court. And that was just because that's the architecture they had. There wasn't a real robust federal government presence, and the church hierarchy is what they relied upon. So that's how things were decided. And it's interesting that even this continued on for a while, and we'll see instances of it even though after we get into Utah being a territory. So, speaking of which, the territorial era. Well, in 1852, the first territorial legislative assembly, they made their first attempts to kind of wrangle the power away from Brigham Young and the church hierarchy, right? And so what they did is they passed a law that said that the county courts were the ones who could issue permits for timber or diverting water. So it wasn't up to the bishops and the stake presidents anymore. And that sounded great in concept, right? But it pretty much, Salt Lake County was the only county that followed it, and it was still kind of moot because the county court to be a judge on the county court, you had to be elected to that position. So you can imagine who these settlers were electing to the position of county judges, right? It's going to be their bishops and their stake presidents. So there wasn't really a whole bunch of difference of how it was handled outside of the church architecture. And again, wasn't really followed. People continued to divert without any worrying about the county court. Well, in 1877, the Desert Land Act was passed by the United States Congress, and really this was an effort to incentivize the settlement of the West, right? They just acquired this huge chunk of land, now they need to settle it. And so this was something that was incentivized people to come out and homestead, 160-acre tracts. But they realized that in the arid West, you had to be an effective homesteader, you had to grow something on that. Well, in Utah, you don't have water that's readily available. Not everyone can live next to a creek or a river. And so this concept that, well, we need to divert from this and we need to use it over here. That concept kind of confirmed that you could divert water away from the natural source. So back east, you had this riparian law that if you lived right up against a river, you had an automatic right to use that river. In the West, it was opposite, that you had to acquire a right, and the fact that you lived right next to a river didn't automatically give you that riparian right. You had to appropriate it, and you could use it somewhere else. Another kind of secondary result of this legislation was that it delegated authority to the respective territory or states in handling water rights, which are a kind of a property right. So you may recall, if you know your history, that the government land office, the GLO, was still issuing patents for people as they had homestead parcels. And so you might think, well, it seems reasonable that the federal government would do the same thing for water. Well, this severed that and said, nope, the territory, the states are responsible for dealing in property rights associated with water and water distribution. So it's significant. And it's the reason we exist as a state agency. Well, in 1880, they realized their failure to really get the county courts to appropriate water, and so they tried to do something else. They said, all right, what we're going to do, this isn't working. We're going to legislate this position called the county selectman, and he's going to be kind of an ex officio judge on these rights, but they're going to be appointed by the executive branch. Never worked out. The courts found it unconstitutional to have an executive authority adjudicating property rights, so for all intents and purposes, it failed as miserably as well. It wasn't enforced. We have found some of these certificates that these selectmen would file with the county recorder. We have found some in Salt Lake County, but for the most part, everywhere else, we've never really found any. As a result of this, confusion continued in spite of the best efforts of both the territorial legislative assembly and the LDS Church. And the church continued to administer and decree water rights. A classic example of this is the 1879 High Council decision on the Spanish Fork River, just down the road here, right? So in 1879, High Council, the church, High Council, made a decree saying, all right, this company gets this much of the Spanish Fork River, this company gets this, and they kind of distributed the Spanish Fork River. And to this very day, that's how that river is distributed, based on that. Now, there have been subsequent decrees to that, but that was kind of shows how the church had a continued influence on the distribution and administration of water. So let's talk about statehood. Well, Utah became a state in 1896. There was a lot of debate and confusion and controversy over what to do with water rights and the distribution of water. And I see you guys taking photos of these slides, which is 100% just great. I just want to make sure you guys know that this will be video recorded and posted online. You'll be able to view it tomorrow. I also post the slides in PDF format on our website as well. So if you want to save your phone, that's fine. But otherwise, feel free to take any pictures you want. Well, as part of this controversy, there was some discussion of, well, should the state just take over all the water and say anyone who's been diverting water, you'll have to apply for it again? There was some concerns about Utah becoming a state and the heavy-handedness of the government. You can imagine a lot of people didn't trust the government given the Mormon pioneers' experience and those types of things. There's a lot of distrust. And so what they decided to do is say, hey, we're just not going to deal with it, but what we will say, we'll write it into the Utah Constitution, Article 17, that all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. And what that did is said, hey, if you've been using water, you can continue to do so. Those are confirmed rights. You're good to go. Don't worry about it. And that's all they left. They didn't say anything else because it was a controversial subject. They decided, well, we're just going to punt. Well, in 1897, the office of the state engineer was created. A gentleman by the name of Willard Young. You can probably imagine who his father was, right? He was appointed to be the first state engineer. But his mission, or his job, was simply to map the area, to map all the streams and rivers and springs, to kind of get a sense for what water resources were available. To appropriate a water right, you still had to kind of go through the old-fashioned way of staking your claim. You'd go and actually stake a physical claim by your point of diversion and then go file that claim at the post office or the county recorder. And again, those are largely ignored. So the state engineer's impact on water rights was really minimal. He was just mapping stuff, not a big deal. Maybe finding areas that you could build dams, and that was pretty much what it was limited to. Well, in 1902, the United States Reclamation Service was created, and that's what we now know as the United States Bureau of Reclamation. And their mission, as their name implies, was to reclaim the arid West. And how would they do that? Well, they would go into areas and they'd build gigantic reservoirs, big dams with big reservoirs, so farmers could take that water and put it to beneficial use and irrigate it, and people could homestead and populate and move to the west. Well, the Bureau of Reclamation, or the Reclamation Service, was really reluctant to go to any state that didn't have some type of water rights law in place for finding out all these old water rights. Remember these historic rights that were recognized? We call them diligence rights or pre-statutory rights. The Bureau didn't want to build any project where they didn't know what the shape of the rights were, what the status is. They weren't going to go build a dam on the Provo River and then find out that they had no water to fill the dam because all that water had been appropriated already, right? And so what they did is said, hey, states, you need to get your act together. We aren't going to build any projects in your state unless you create some fashion of water law, some form of water law for the adjudicating of old rights, but also for appropriating new rights, which makes sense, okay? But it's mostly they were worried about the old rights. They wanted to find out what these pre-statutory rights looked like, how many there were, before they really invested in building big projects. So it's no coincidence that in 1903, 1 year later, the state of Utah came up with its first formal body of law that governed the appropriation and adjudication of water rights. Now, the theory was that they would adjudicate all the old rights, all these historical rights, to find out where they were, and then once they figured out, all right, how much water had been appropriated, then they'd start appropriating new rights. But we'll kind of get into why that didn't happen out. It didn't work just like that. So in this original law, it provided a mechanism for recording all the existing rights and for adjudicating. But what they pretty much said, all right, what we're going to do is we're going to set up a framework, and we're just going to say the courts will adjudicate the water rights. Well, if you're familiar with the court system, it's an adversarial system, meaning you need a plaintiff and a defendant. You can't just simply say, courts, go adjudicate water rights, because the courts are waiting for cases to come before them. And so without that, they don't really have any framework to operate within. They can't decree water rights until a case is brought to them. And so there wasn't really a lot of adjudicating going on. There wasn't a lot of finding out these old rights. And any adjudications that may have happened, any court rulings that would have happened, would have only been between the parties, right? So party A and party B may disagree with respect to each other's rights, and the court might make a decision, but that says nothing with respect to how party C's rights interfere with party A or party B. So you can see it wasn't a great system that they'd come up with. Also, they didn't really provide any funding to the courts to do this, so it kind of fell on its face. Now, this 1903 law only applied to surface waters. Did not apply to groundwater. You could still drill a well. They kind of figured, it was back in the olden days. They knew that the waters were connected, but they'd said, groundwater is too hard to figure out. If you want to drill a well, you can do it. You don't need a water right. This is only for surface rights. It's for rights coming down like the Provo River and those types of rights. Well, in 1919, they finally figured out that, hey, the courts just aren't getting the job done. They aren't adjudicating these old rights. So the legislature provided this new framework, which had been developed up in Oregon. It's called the BN system, where the state engineer would go out and he would do a survey of the area and then make a recommendation, and that recommendation would be called the proposed determination. And then he'd give that to the court, and then the court would make a ruling on the proposed determination. And if people didn't like the proposed determination that the state engineer had recommended, they could come in and argue it before the court. And so that is largely the system we have today, is this proposed determination system. There have been some tweaks and modifications subsequent to that 1919 piece of legislation, but that's really the basis of the framework we have. And again, this was only for surface waters. Well, in 1935, they finally figured it out that surface waters and groundwater are all the same water. And they said, well, what we need to do to ensure that we're not impacting surface rights, we need to start tracking underground diversions and wells. And so after 1935, they started requiring you to appropriate or have a water right to divert groundwater. So prior to 1935, you didn't need a water right to drill a well. After 1935, you did. Prior to 1903, you didn't need a water right per se to have a surface right. After 1903, you needed a water right. And so when we talk about pre-statutory rights, we're talking about those two key dates. 1903 for surface rights and 1935 for underground rights. So prior to the enactment of this law, water rights kind of fell into a few different categories. First of all, there were those rights that were just, decreed through ecclesiastical fiat, like, yeah, the bishop said you get this right and you don't, okay, or the high council in that case. There are some claims that were filed at the county recorder. These are largely hard to find. The recorder didn't really know where to put them. We found some, again, mostly in Salt Lake County. There was those that were decreed by a court, but you remember, these were limited to the parties involved. So Party A and Party B might sue each other over how their rights affect each other, but it has said nothing about Party C, okay? So, and then you had, kind of a judge who really didn't know anything about how water or irrigation works, making decisions that typically over-appropriated the streams. There were some contracts or agreements that were just entered into between parties. A lot of this happened in Salt Lake Valley between Salt Lake City and other water users. They liked the nice, clean mountain water, and they said, we'll give you this rotten, filthy Jordan River water, which is great for irrigating, but we want your clean little Cottonwood Creek water for municipal use. And so Salt Lake City would enter into these contracts. Then you had these claims that were never manifested on any record, and these are those pre-statutory claims. These are the rights that people started using. They really had no reason not to use them, and they continued to use them, and we still find those to this day. We find more of them associated with the underground rights. There was a great flurry, as Salt Lake Valley and Utah Valley kind of urbanized and grew. It outpaced the ability of the local municipal water suppliers to provide clean municipal water. So what would happen is if you wanted to build a house in some of these areas, you'd have to drill your own well. So we find a lot of these in parts of Salt Lake Valley and in Utah County that are associated with older residences that relied on their individual well to provide their domestic needs before the pipelines made it out to them from their local culinary supplier. So, as a result of the fact that there was no water law, there was a number of issues. First of all, there was no public record. There was limited public records. There certainly wasn't a consolidated public record where you could go and say, I want to see what water rights are on this source or in this area. You couldn't go. You'd have to go find the county recorder. You go to the county recorder's office, and the county recorder's like, I have no idea what you're talking about. And then you'd have to look through all these books and stumble upon stuff. And that's pretty much how it was. Because there was no record, over-appropriation was pretty rampant. People would take a lot of water, and because they took more water than there was actual in the stream, there's a lot of controversy, and that controversy had to be either settled through ecclesiastical channels or through the courts. And so in his biennial report, so back in the old days, the state engineer used to file a report every 2 years. As you can see from this is from 1901-02. Again, the state engineer's office was created in 1897, so this is one of his first reports. And he kind of talks about, hey, this is important that we figure out what these old rights were. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So his idea was, hey, we got to figure out what all these old rights are first before we can start appropriating new rights. Unfortunately, legislature didn't really fund it. They didn't give them a great mechanism, so they just said, you know what, we're just going to start appropriating new rights. We'll let the adjudication catch up with the appropriations. And here we are, right? Finally getting around to it. So it was great in theory, is not funded, and so a lot of these old rights continued to exist, and they just started appropriating new rights. So what is a general stream adjudication or a water rights adjudication? As the name implies, and as I've already said, it's an action in court. It's actually an action in state district court, all right? It binds all the water users in a particular subdivision, including the state engineer. So it's not just between party A and party B and leaves party C out of it. It gets everybody, okay? It's governed by Title 73, Chapter 4 of the Utah Code. If you're really interested in reading that, good luck. It's not super intuitive, but if you want to burn through it, let me know. I'll help you, give you some Cliff Note versions. Then the first general stream adjudications happened in the 20s, and you can remember in 1919 when they finally gave them the proposed determination mechanism, then they started doing those. So if you look at this map, this multicolored map, each of those areas, different colored areas, are a different adjudication, okay? And they're usually on stream-wide basis. So you'll see the Weber River adjudication got started back in 1919, the first year we had a proposed determination process, and it actually got finished. There's enough spare labor, because you know what was going on in 1919, right? It was the Great Depression. They had a lot of people hanging out that they could use cheap labor to figure this stuff out. Another adjudication, that wrapped up pretty quick, was the Severe River adjudication. And then a lot of these other adjudications happened later. The one that we are concerned with is this big purple one in the middle called the Utah Lake Jordan River General Adjudication. And so it, in essence, it incorporates all the tributaries to both Utah Lake and Jordan River. And so it's a big mass. It goes all the way up, it chases the Provo River up to its headwaters, and it chases the Spanish Fork River up to its headwaters. So that's why it's so big. Now, when we talk about the Provo Canyon Subdivision, we're really just talking about a bite-sized piece of this general adjudication. You'll note that it didn't get started until 1936. It says 44, but it was 1936. There's some court cases, but it started in 1936 because there's a huge drought. You guys remember what was going on at that time? There was the Dust Bowl, right? Well, this is kind of the same time frame. We had a huge drought in Utah. People were diverting out of the Jordan River without water rights, and Salt Lake City was really irritated about that. And they said, state engineer, I want you to adjudicate this so people stop stealing our water. And the state engineer said to Salt Lake City, you know what? We are bankrupt because we just finished the Weber Basin and the Sevier River, and at that time you had to pay money to have your claim evaluated, and that's how the state engineer got its funds. They said, and no one's paid us back, so we have no funds to do it. So they said, fine, what we're going to do is we're just going to sue 5,000 people or 1,000 people, I can't remember. It was some insane number in a private litigation. And the court said, Salt Lake City, you can't do that. It's got to be a general adjudication. By that time, there was enough pressure from the public on the legislature to appropriate funds to the state engineer, and that's why it got started. You'll notice that some of these, and you probably won't notice because you can't see because it's really small. A lot of these started in the 50s, and there's going to be another reason I'll talk about that. But the one we're talking about is Utah Lake Jordan River, started in 1936. It's the oldest running civil case in the state of Utah. So if you guys are familiar with the legal system, when they give you civil numbers for your court case, the first two digits are the year number. Well, this starts with the year 36, and when we started working again with the county, with the district court, asking for the records for this civil number that began with 36, they looked at us kind of weird, like, 2036 is in the future. Why do you have a court case with that number? And we had to explain that no, actually it's 1936, and it's still open. And so it's just one of those neat little facts you can share at your next cocktail party or whatever. So why do we conduct general adjudications? We want to bring all the claims on the permanent record. Remember this guy, he's out there using water, doesn't have a care in the world. He has a pre-statutory water right, either a surface right that was appropriated prior to 1903 or an underground right that was appropriated prior to 1935. We call those pre-statutory claims. Sometimes we'll call them diligence claims or underground water claims. But I'm just going to use the term pre-statutory claim or diligence claims to cover that base. All right, we want those claims to be brought on the record, because right now they're just using water. We don't know why or how much they're using, what their rights are. This adjudication requires them to bring their claim onto their record. Another thing, Federal Reserve water rights has nothing to do with the Federal Reserve that prints money. It's actually a legal concept that has huge implications for the state of Utah. So back in the turn of the century, the Fort Belknap Indian reservations, the Native Americans that lived on that reservation were trying to do the best they could to do what the United States had told them to do on a reservation, become kind of an agrarian-based people. But they couldn't without water. So they went to the state engineer of Montana, or the equivalent of the state engineer of Montana, and said, we need to appropriate some water out of the Milk River in order to become the agrarian people that the United States expects us to be. And the state engineer said, hey, I'm sorry, all the settlers have fully appropriated the Milk River. You are out of luck. No water for you. Well, you can imagine they didn't take that very well, so they took it to the Supreme Court, and the Supreme Court ruled that by virtue of the reservation, the Native American, the Indian reservation being taken out of the public domain or being reserved out of the public domain, Congress had intended an implied water right for that reservation. And so what that water right was, well, they didn't say. They just said it's whatever the needs of the reservation are. So this was a concept that had then continued to be evolved. And you might say, well, how is that meaningful to the state of Utah? Well, we do have some Indian reservations, and this Winters Doctrine is applicable. We have these Federal Reserve water rights that we don't know what they are, how big they are, we just know they exist. And they have a priority date equal to the reservation date, so the date that property or that land was taken out of the public domain. But you can also imagine there's other types of federal reservations. So there's national parks, there's national forests, there's military reservations. All of these different reservations have these unquantified, unknown water rights associated with them. So you can imagine the uncertainty that that casts upon the local residents or citizens of the respective state. If we know that the Forest Service has a water right for all of this Forest Service property up here, but we don't know how much that is, and it's equal, has a priority date that's equal to the reservation date of the forest, it casts a lot of uncertainty on the rest of us trying to appropriate water, and we don't know really how much water there is, because if someday they finally said, hey, we're going to use our Federal Reserve water right, and we are going to cut off the Provo River because it runs through Forest Service and we need it all. You can imagine the implications, right? No, they'd never do that, but that's the type of stuff that kind of hangs over our head. Well, there was a senator from Nevada, Senator McCarran, said, hey, that's just not fair. Here we are, we've got these states, they're trying to manage their resources. And the thing about the federal government is you can't sue them unless they let you sue them, right? It's they got that federal sovereign immunity. So unless they let you say, yeah, go ahead and sue us, you can't do it. You can't take them in court and say, define your water rights. Well, Senator McCarran thought that was unfair, created this piece of legislation that we call the McCarran Amendment, which says the federal government waives its federal sovereign immunity in water rights adjudications, meaning they are required to come forward and participate and be a party to these adjudicative proceedings to define their water rights. And not only that, they've got to do it in state district court. So, it's even better, right? Do you know of any other federal lawsuits that can take place in state district court? I'm not familiar with many, if any. So this is kind of a unique thing that the federal government has to come in. They have to submit their claims. They have to quantify those claims and say, this is how much water our Federal Reserve water right is for. So adjudication kind of is the sword of Damocles that kind of hangs over them saying, you better come to the table or you're not going to get anything. So it's really important. And you'll see that McCarran Amendment is in 1952, which prompted us to initiate a bunch of these other adjudications throughout the states in the 50s because of that amendment. Another thing we want to do is prevent multiplicity of suits. We don't want everyone suing each other. We just want to have one big powwow, one big lawsuit, and get it over with, right? Rip the hangnail right off, rather than everyone just kind of nickel and diming each other for water rights. Okay, here's the more controversial aspect. This is probably where I'll start to get questions. So in the West, the arid West, as I've said before, there's less water than there is the demand, right? And so to account for that, to incentivize the use or the most beneficial use, and to avoid monopolizing the water, our forefathers, and this is common through all of the Western states, said, hey, if you don't use your water right, you're going to lose it because that water can be used by someone else. And also what we don't want happening is some big banker coming in and appropriating the entire Provo River and then holding on to it and then dishing it out and becoming a monopoly on that system, okay? And so this concept of use it or lose it was incorporated into Utah water law from the very first day. And this same type of concept is evident in Colorado's law and Wyoming's law and Nevada's law. It's just a Western water law feature because we have less water than there is a demand for it. So we want to make sure that people who have water rights are putting them to beneficial use. So one of the things in the adjudication that we look for is look for water rights that are no longer being used. And then we make a recommendation to the court, hey, court, this water right hasn't been used for 7 years or more. We recommend that you forfeit it because it's been abandoned. And you might say, well, that's not fair. That's my property right. It's just not fair. And I understand that, and that's a common theme. But if you look at it from the water users from a different perspective, I think you might see it a different way. So let's talk about that. So let's say you're a water right owner and you have a water right for 100 acres of irrigation and you stop using that for 50 years. Well, that water is going to continue to go down and people are going to divert and use that water. And in fact, entire communities might be developed based on the water that was once associated with your water right. So were you to suddenly, 50 years later, resume use of that water, suddenly everyone who's become dependent on it is now out of luck, right? And so we're trying to ensure that there's certainty in the ability of people to develop their water, and incentivize use. We don't want people to have the rug pulled out from underneath them by someone who hasn't used their water in such a long period and then resume it. Again, this was the concepts that our forefathers thought of when they drafted this law. I understand that it's controversial and people have a hard time accepting that. I fully acknowledge that, and I'm happy to talk more about that, but that's just one of the things that we're going to be looking at when we go through and do this adjudication. Lastly, we want to get a final comprehensive decree on all the water rights. So when you appropriate a water right, you file an application, and then you're required to file a proof on that application saying, yes, I've used it. And then you get a certificate from the state engineer saying, this is now a certificated water right. But really what you're getting is that you have a prima facie evidence of your water right. It's not really, it's as much of a water right as you think you have, and there's no evidence that you don't have a water right, is really all that's saying. But a decreed right is an actual water right. It's just a hair better than a certificated water right, but in truth, we treat them the same, whether it's certificated or decreed. But a decreed right is just like, I guess, gold-plated, I suppose. So let's talk about the adjudication process. It's a 3-phase process. We're at step 4 right now. We sent out, so the petition was actually initiated by Salt Lake City when it sued all those people. So that's really what started this one. But we've published notice in the newspaper. We've sent summons to parties or potential parties. And now we're having our public meeting. These are all statutory requirements. And so this is just kind of my best snapshot or icon view of the statute, okay? Let's talk about the next, and we're going to dive a lot more into the details on each of these. So don't feel like you've got to digest this in one fell swoop. We'll talk a little bit more about what your next action is, your next step is, okay? So after this meeting, we're going to send out another mailing. And if you receive the mailing to come to this meeting, you'll receive this next mailing. It's going to be a notice to file claims. And you'll have 90 days to file a claim on any water right that you are asserting you own or you use, okay? Any water right that does not get a claim filed on it goes on this list of unclaimed rights, okay? So if we know of a water right, we have in this area, I think around 200 water rights of record, meaning people have applied for these, appropriated these water rights. If someone fails to file a claim on that, it goes on this list of unclaimed rights, and then we send out notice to everyone, hey, these rights haven't been claimed. We send it out to everybody. People have 90 days to say, no, I don't know why I failed to file a claim on this right. They can file an objection and a claim. Again, I'll get into that here later. Eventually, we'll hold another public meeting for this list of unclaimed rights. And then, if those rights remain on that list, the court will enter a decree saying those rights have been abandoned. By virtue of the fact that no one has filed a claim, their inaction is kind of demonstrated their lack of intent to use it, and so the court then issues a decree saying those rights are abandoned. And then we will have, the court will also issue a decree saying, hey, no more filing diligence claims. So up to this point, people could file a diligence claim saying, hey, prior to 1903, my great-great-grandfather diverted water and applied it to this ground. Or prior to 1935, my great-grandfather drilled a well and used it in this house. After this happens, you'll no longer be able to assert those claims. So that's one of the cutoffs associated with this process. Well, when someone files a claim, someone from Josh's team will come out and actually evaluate it. They'll take a look at what you file. They'll come in and look at the actual beneficial use. So if you file a claim for a domestic residence and a quarter-acre of irrigation, they'll come out, look to see that the well is connected to your residence, look for the irrigation, just to verify the claim. And then we'll make our recommendation in the form of a proposed determination there, step 12. Again, this is what we try to work with the water user before we even get to this point. So what we do is we'll evaluate the claim. We'll send you a copy of what we're going to recommend. And if we screwed something up, you can just say, hey, you missed something, and then we'll come back and we'll fix it. Again, we're not looking to to sneak anyone's water away from them in the cover of night, okay? We're trying to we want to maximize any rights that exist. That's really our emphasis. I know that it may feel otherwise, and I hate to say that we are the government and we're here to help, but we really are trying to help here, help people navigate through this process. Again, if we screw something up in the proposed determination, or if you don't like how we've evaluated your right, you can file an objection within 90 days, and then we go through court and we either litigate it. But again, I'm going to dive into these now. So this is just kind of the one-over snapshot of the process. Ultimately, once we get here, we want that final decree that decrees the water rights. So let's talk about filing your water user's claim. On October 17th, we are going to mail out notice to file water user's claim. So you can expect maybe 2 or 3 days later, you'll see it in your mailbox. If you received the mailing tonight, you'll receive this. People or individuals who have a water right that we have a record of will get a water user's claim that's already filled out. It already has all the information that we have on our records, and all you really need to do is just sign it and then send it back to us, or even scan it and email it to us at that email address I showed earlier, and I'll show again, or to Josh's email address. If you're simply a property owner, and I should clarify that we sent these notices and these summons to all property owners within the Provo Canyon area. So if you're wondering why you're here, because you don't have a well or you don't have an irrigation ditch, it's because your property came up on the county recorder's records as being a potential property owner here. So if you're one of those individuals, we will send you a blank claim form. And we understand that the claim form is probably not really is difficult to navigate or understand. We encourage you to call us up or come visit with us, and we'll help you fill it out and file it. And you just file it with us. There's no charge. Just simply get it to us before the 90 days expires. So that's what I'm talking about, 90 days. So from the date of the mailing, so from October 17th, 90 days beyond that, you've got to file this claim. And you can request a 30-day extension, but that request, you can use that same email address that I showed. Just shoot me an email saying, I request an extension for this subdivision, and then you get an automatic additional 30 days. That request has to be filed or emailed or sent to me prior to the expiration of this original 90 days. If you don't file your claim within that 90-day time frame, then a water right of record will go on this list of unclaimed rights, which I'll get to here in a minute. But when the claim comes in, it will go to Josh's team, and he'll arrange a date and time to come out and take a look at it. Obviously, we're coming in on the winter season. Probably some of these claims won't be evaluated until springtime. We might look at aerial imagery, historical aerial imagery that we have access to, just to kind of get a sense for it. But for the most part, if it's a challenge to actually look at irrigation in February up in the canyon, you can imagine that's going to be an obstacle. And then we'll evaluate the claims, we'll map it, and we'll send you a copy of what we're going to recommend in the proposed determination. So a list of unclaimed rights, I kind of already touched on it. If people fail to file a claim on it, on their water right, that water right will go on the list of unclaimed rights, and on the list of unclaimed rights is literally just a list of the water right number, the owner of record, and the location of the point of diversion and the source. We send out that same notice, so if you receive the notice tonight, you'll receive notice of this, and we'll hold another public meeting. Usually that's not very well attended, because usually people who fail to file a claim are really on water rights that have long since been abandoned anyways. For instance, if it was once a well and now it's a Walmart parking lot, there's no sense in filing a claim, so some people just say, I'm not going to bother with it, I'm just going to let it go on the list and be abandoned. Again, we send the notice out. People have 90 days to file an objection and a water user's claim. So now that this is kind of in the court, we've sent our recommendation, the list of unclaimed rights to the court. Now you've got to actually file this objection with the district court. Don't file it with us. You are required to file a water user's claim with us, but your objection. But again, if you don't know how to do this, call us up. We can't really give you legal advice, but we can say, hey, this is what an objection looks like, and this is where you file it. And so we'll kind of help you out there. Again, we want people, if you have a right on the list of unclaimed rights and you just space it or for some reason, we want you to file a claim. We want you to preserve your water. So we encourage people to work with us, and we'll try to help out as much as we legally can without crossing that line. Then we go into this litigation phase, but I'm telling you right now, if you file an objection and you have a reason why you failed to file a claim, we just recommend the court accept it and the claim be taken off the list of unclaimed rights. So it's not really controversial. We simply roll over and say, great, you filed your claim. Let's move on to the next step in the process. Again, once those objections are resolved, the court will issue a decree that states that all of these rights that no claim has been filed on have been legally abandoned, and they just become dead. They don't go to somewhere. They don't go into the state engineer's pocket to reuse or anything. They just become invalid, okay? And then the court will also issue a decree that closes the area to any more claims being filed. And when I say claims, I'm talking about those diligence claims, those pre-statutory claims, that after that, you can't file those claims. You can't assert that you had a pre-statutory use. So that's one of the advantages, is we get some finality in that. Let's talk about the proposed determination. So we got the claims, we've done the evaluation of those claims, we've sent a copy to the claimant saying, hey, this is what we're going to recommend, and then we get all those recommendations and we compile it into one big book, and we send notice to people who filed a claim. So if you don't file a claim, you won't receive notice of this proposed determination unless you explicitly come and tell me, no, I want to receive notice of the proposed determination even though I'm not a claimant. But the invitation to view this and go to this party, it really only goes to those people who have filed a claim, okay, or their legal counsel. Proposed determination, again, that's our recommendation to the court. We'll hold a public meeting to answer any questions about that proposed determination. People can file an objection similar to the list of unclaimed rights. You have a 90-day window to file an objection saying, no, the state engineer got it wrong. They missed some acreage, or the point of diversion is wrong, or some other facet of it is incorrect. Hopefully you've told us before when we've sent you our original recommendation that so we could fix it. But sometimes there's just, we're going to disagree. Sometimes you'll have a position and the state engineer will have a different position, and we can't come to an agreement. So the state engineer is going to put his position in their proposed determination, and the claimant will file an objection. And then we do a couple of different things. We can either negotiate a settlement or we can litigate it. All right. If we really disagree, we'll litigate it, and we'll schedule a time in court with a special master who presides over the objection process, and you'll have to get an attorney, or maybe you'll just defend yourself, and we'll get the Attorney General's office involved, and we'll litigate it if we really disagree. Usually what happens, though, is we just settle. We figure out a way that's a compromise sometimes, or maybe if we just made a mistake, we'll just fix it. We'll admit it, and we'll fix it. Sometimes people will file an objection because they're confused and don't understand what the proposed determination is saying, and once we explain to them what it is, they can withdraw their objection as well. So there's kind of three ways. The claimant can withdraw their objection, we can negotiate a settlement, or we can litigate it. And those are kind of the three ways we have to resolve objections. And lastly, we have, once those objections are resolved, we petition the court to enter a decree on all of the rights in the proposed determination. And then those rights, whatever their status was prior to that decree, now become decreed rights, which are just a little bit better than perfected rights. So, Provo Canyon Subdivision. So on the notice you received, you saw this map. It just didn't have all the purple dots. Those purple dots represent points of diversion, generally associated with water rights that we are looking at in this subdivision. There are 202 that we're counting. Now, Josh Zimmerman and his staff have a big map of the canyon that you can go look out afterwards out in the hall and try to find your property or your parcel and see what we have. And it'll show the actual water right number. Now I'm going to show you an interface afterwards where you can find that yourself as well with Google kind of Google Earth imagery with these points shown. So I'm going to show that to you. But this just kind of gives you a sense of where the bulk of the water rights are. There's a lot kind of down in the Provo Canyon, Provo River area, and then you got some up here and then over here in Vivian Park as well. Most of the rights of record are surface sources, which is really different than what we traditionally done down in the valley. We see most of them are underground sources. In this area, they're mostly surface sources with a lot of Forest Service claims, all right? A lot of claims that the Forest Service has filed for stock watering. Usually, so you see this number of people notified, we send out about 1,000 notices. And you might say, well, that's a lot. It actually is. Usually we're sending out 10,000 notices. I'm actually really surprised to see this many people here because we'll send out 10,000 notices and we probably still get about the same number of people. So I applaud you for being more active or based on the number of notices we sent out. And again, this just shows you the different adjudication areas. We're talking about this big purple blob in the middle of the Utah Lake Jordan River, and this is just a bite of that. Again, this was started in 1936. We've kind of taken these bite-sized pieces out year after year after year. So you ask, why are you here now? And the answer is, because we're here now. You know, we've circled around, kind of worked our way down Salt Lake County, have kind of jumped into the Utah County, and are kind of chasing the Provo River up to its headwaters. It's kind of the progression we're going right now. Okay, issues and anticipated timeline. Often we have a lot of out-of-date title on our water rights. And what does that mean? So when someone appropriates a water right, we'll just say John Smith appropriates a water right back in 1945. It doesn't really matter. He puts his name down as the owner of record. Well, and let's just say this is a well on his house, okay? Well, he sells that house and the well. Someone moves in, and they update title to their house with the county recorder's office, but that doesn't tie into our records. So our records will continue to show John Smith as the owner of that water right. So why is that problematic? It's not super problematic. It doesn't mean you aren't the owner of the water right. It's just on our records doesn't reflect that you are. You most likely are. Water rights are conveyed by a purtenance unless they're explicitly withheld. So if you are selling your property and there's a water right associated with it, if you deed that water right to whoever's purchasing it, the water right is assumed by Utah water law to have gone with it, to have transferred with it, unless you explicitly withhold that in the deed, okay? But generally, they just kind of pass along, and the new owner, probably not being very familiar with the water rights process, doesn't know that, hey, this well has a water right, and it's in the name of the previous owner. And this can actually go through several different generations. So our records typically, or in some cases, in a lot of cases actually, don't reflect the actual owner. So some of you may have seen this. You may have received a notice at your house with some other person. So it's your address, but has some other person's name on it, right? That's because the owner of record is still in someone else's name. Does that mean you can't participate? No, you can continue to file a claim on that. I'll get to here in a second. You can file a claim and just say you're a claimant, and then you can update title to that water right later. Did you have a question, ma'am?
Yes, I did. You're talking about selling homes and names changing. In our particular case, we've had water rights since 1907.
Okay.
And it's been under the same name, the Wildwood Corporation, all of these years. So that you should still have record of, and that would not pertain to us, correct?
Yeah, so her question was, just for the benefit of the rest of their group, you know, I've talked about water rights associated with a well and the property changing hands, but if the water right, in your case, was originally appropriated by this entity, was it Rosewood or? Wildwood. If that's the original owner of record back in 1906, and there's been no changes, it would, continue to be reflected that way. And we can look at it. It's pretty easy, and you might already have your records. But there shouldn't be any change, only unless someone actively came to the state engineer's office and says, I am going to update title to this water right in my name using this report of conveyance. And there's a specific report, has to be done by a title professional, and so there's no, to avoid any type of mischief, someone updating title to a water right that doesn't belong to them. So there's a process to update title to a water right that we can talk about. But all I want to say is that's important, but don't let that prevent you from filing a claim on a water right that you believe you are the owner of, even though it may not show you as such on our records, okay? That was kind of the big takeaway from that. All right, location of no proof required. There's probably not as many of these, but I'm going to talk about it anyway. So no proof required. So back in the 40s, in order to perfect a water right, you're required to file proof. And you have to have an engineer or a surveyor do that. And that requires them to come out and actually survey in where the point of diversion is and map out where the use is. And that's what we call a proof. Well, in the 40s, a lot of those professionals were fighting Hitler or the Japanese in World War II. And so the Utah State Legislature said, hey, we don't have a whole lot of professionals who can do this. So in order to make people's lives easier who just want to build a house, we're going to say that you don't need a proof. You don't need to file a proof on small water rights. And it was like for one domestic it's just one domestic and a few stock is really what it was allowed for. And we have a lot of those in Salt Lake Valley and probably in Provo or area. I don't think it's going to be as prevalent up in Provo Canyon, but it may be. But the reason I bring it up, why that's an issue, is because usually what happens when people appropriate water right, they say, I want to drill a well in this area, kind of generalized area. And the state engineer says, okay, you can go and drill a well, and they'll drill a well, and it might be in a different location, generally speaking. Well, what the proof does is it ties down the exact location of where that well is, and that's the benefit of having a proof and having an engineer or a surveyor identify that. Well, if you don't have that requirement to file a proof, we don't have a very good location. We have a general idea of where the point of diversion and the beneficial use is, but we don't have an exact idea. And so what you will see when I bring up the map interface later is that sometimes these points of diversion may not physically appear or may not show where they are physically located on the ground. So they might show a point of diversion or a well in the middle of a road, even though it's actually in your backyard. So just be aware of that. And there are some other issues that associated with mapping and tying to section corners. I'm not going to get into the weeds on that. There's a couple of issues that also play into a reason why our map interface may not truly reflect the actual location. But as part of the adjudication process, we're going to fix that. We're going to tie it down with a GPS coordinate and make sure it's reflected where it truly is. Let's talk about anticipated timeline. So as I already said, October 17th, we are going to send out notice to file claims. So that's the date that we mail them from state mail. So you'll probably see them a couple days later. But that's the date per statute that 90 days begins. So that means January 15th is when that 90-day period concludes. So you'll need to file your claim within that 90-day period. Unless you request an extension, then you get another 30 days. But you have to file that request before January 15th. Around April is when we're hoping to publish the list of unclaimed rights. Again, it depends on a couple different factors. Some of the factors include when we can get this building, what other meetings we have scheduled, and other projects we're working on. But hopefully in April is about when we expect to. July, if we publish the list of unclaimed rights in April, you'll have 90 days to file an objection to the list of unclaimed rights, which means that expiration date would conclude in July. And then a whole year later, after we have an opportunity to evaluate all these claims, August of 2021 is when we hope to have the proposed determination published. And we're also, for this Provo Canyon, this Provo drainage, we're holding off the publication of all the proposed determinations so we can do them all at once. And the reason for that is because the Provo River is connected. And those of you who are familiar with it, there's a Provo River decree. And we want to make sure that if there are going to be issues that are going to be fought in court, we don't want to fight them several different times. We just want to be able to consolidate them into one issue before the court and get it resolved for all the different subdivisions that are along the Provo River. So that's why there's a little bit of a delay in the publication of the proposed determination. It's because we're going to wait and do all of them at once, and we have to get all the way up to the headwaters of the Provo River before we're ready to do that. And then assuming that we publish the proposed determination in August, we will use that 90-day objection period begins and will conclude in November, again, if we publish in August of 2021. Okay, biggest question, will I lose my water right? If you're a water user and you have a water right and you're using your water right in conformance with the records of the state engineer, and as long as you file a claim, you really don't have anything to worry about. We're going to come out, it's going to be too easy, right? We're going to come out, we're going to look at your claim, we're going to see that you're irrigating this much, you're using it on this house or whatever. Shouldn't be an issue. If you're not using your water right, try to do this as subtly as possible, but just, hey, put your water to use before we get there, all right? And that's all I'm going to say. Like, we're not going to do this whole CSI water rights and say, hey, have you been really using this water? But if we come out there and you're using the water, we're not going to look any further, right? We're just going to say, nope, looks good. So let's make sure you put your water to use when you file your claim and we come out and we look at it. But by the time, if we come out and look at it and you're not using it, don't expect us to come back and say, well, now put it to use and we'll come back later and look at it. So that's as much as a heads up I'm going to give you. Again, I encourage water use, using on your rights. We want people to preserve their water rights, and whatever I can do to kind of give you a heads up that, let's get this going, let's do that. Again, if you haven't used water for 7 years or more, that's when it's subject to forfeiture, okay? And if you fail to file, so if you're one of these people that has been using water prior to 1903 from a surface source and you don't have a water right, this is your opportunity to file a claim on that water. If you fail to, you will forever be barred from doing that in the future, okay? Yes, ma'am.
If you come out in the winter, a lot of this area is very low temperature and people aren't going to be irrigating their gardens.
That's outrageous. You're not going to be irrigating in the middle of winter.
Well, and you might be in St. George for a couple of months.
Yeah.
Are you going to be penalized because you're not using water at the rate and the house looks like maybe no one's home that day you come?
Yeah. So our question is, if we, it really boils down to how are we going to review these? Are we going to take into consideration whether someone's actually home, whether it's the time of season? Obviously, we're not going to be looking for irrigation in the middle of February. That's ridiculous, right? We might look at a map. We might look at aerial imagery and historical aerial imagery to determine the extent of irrigation. But the bottom line is, what I would hope people would do is to write their phone number or their email address on their claim, because we don't want to come out and look at a claim without the water user there to show us around and show us how they're using it. We try to make our best efforts to coordinate that visit with the water users. So, because you guys know how your system works, right? If we just show up and all we see is a well, we don't know how that is connected to the house. If there is a pressure tank in the house, those types of things that we look for a domestic connection. We don't understand how it's being used for irrigation. But we're not going to come out and look for irrigation in the middle of winter. I like to think that we're not that insane, right? We understand that grass grows in the summer. But we're going to try to coordinate it and do our best to coordinate that. But we are going to come out. And the bottom line is, if you don't want to coordinate and schedule that with us, then we're going to come out and do our best, and we'll probably miss something, and it's going to be to your detriment. So it's to your advantage to facilitate the coordination of our visit rather than being obstinate and saying, if I just stonewall them, I'll get away. It won't happen, because what we'll do is we'll just disallow their right, and then you'll come out, hey, don't disallow it. Let's talk. So let's just work together to recognize your right. Yes, sir.
So then that would make sense that if you have 75 homes, but 30 of them are summer use as of now, you're not using the whole water right, they're using summer use, but they eventually intend to go full time. So that's not an issue. You're still using your water right, even though it's not being used completely.
Yeah, so his question is, you have this community, this development has this number of houses. Some of the houses are used part-time, but they have a water right for a full year probably. We're going to come out, and if we see a house connected to a water system, we're not going to question whether it's only used in summer or not, okay? We're just going to say, looks good. You got what we call an EDU, an equivalent domestic unit. Now sometimes these cabins only have part-time water rights, and so we won't recognize a full-time water right on a part-time water right. So we're not going to increase the water right, but we're not looking for ways to trim it down in that type of scenario. Did you have a question, sir?
How long after we file for the water right thing, if we've had it before, how long until we know that everything's A-okay?
It's a great question. So this question is, after we file a claim, how do we know that we're in the clear of this insane, terribly invasive process, right? You'll know because we'll come out, we'll meet with you, hopefully we'll coordinate and meet, and then we will send you a state engineer's recommendation. And so we're going to send you what looks like a water user's claim, except there's no place to sign, but it'll have the same kind of facets to it. And if there's mapped irrigation, or if there's irrigation, so we'll send you what we've mapped. And so you can say, okay, this is what they came out, this is what they concluded. And we do that for a couple of reasons. We want to give the claimant the opportunity to say, hey, time out. You missed a bunch of stuff here. Fix this, please, before you take it to the proposed determination. We just want to be open and transparent as much as we can. So usually when you receive the SER, you know, hey, all right, they're going to drive on, and this is what will look like in the state engineer or in the proposed determination. Okay, we'll drive on. I think we're at the last slide. So that's me at the top. It's my email address. Gary Brimley's not here tonight. He's kind of my deputy. But Josh Zimmerman, that's your guy you want to be after, because he's going to be one coordinating his team to come out and look at your water rights. That phone number is just so I have 4 different teams and some teams in the regional offices. That phone number will get you to our front desk, and if you just have a general question, you might not end up talking to Josh or his staff, but all of our teams know answers, and they can look at your water rights. But if you really need to talk to Josh or one of his staff, he will get back to you. I assure you of that. Okay, so again, I take some questions. Then I'd like to show everyone on our interface, because there's a way you can print off your claim from online. And even if you're not the owner of record, you can add your own ownership record information. This is a new feature. It's the first time. It's actually went live today. And I can show you how to search for your water right using our interface. But again, let's go ahead and answer any questions you may have. If you're watching online, email your question now, and I'll circle back once I filled some questions here, give you enough time to compose your questions. Are there any other general questions I can answer? Yes, ma'am. Okay.
We've been fighting that for many years.
So her question is, in her situation, she had you were the conveyor of the property, right?
Yeah, well, my father.
Your interest is conveyed, and they reserved a portion of the water.
Yes, he had 25 acre-feet of water, and he reserved out, in words, with this sale, 8 acres of land would be watered by in perpetuity, as long as his family owned that.
So her question is, there's been some controversy between the person who purchased the property has never been honored. And I presume the question is, what's the adjudication going to do about it, right?
Well, yes.
And then the answer is nothing. That's between you and that person. But what I would suggest you do is update title, or ensure that your water rights are squared away, because really we're talking about between you and this person. When we come out, we're going to look at the water right. Let's say we'll get away from acre feet and we'll talk about acres. Let's say 50 acres, and I know it's a made up number. And you said, I reserve 10 of those acres, and this person gets the 40 other acres. Well, on our water rights database, or on our record, it's going to say 50 acres. So we're going to come out and we're going to look for the 50 acres of irrigation. The private battle between you and this other individual or entity,
Gave it to a water district.
and they gave it to a water district, which makes it even worse, right? Yeah, so it's a complicated issue that the adjudication is not going to solve for you. unfortunately. That's not really our purview. What our purview is, come out and look for beneficial use and quantify the water right. What I would recommend, and maybe you've already met with an attorney, but it sounds like this is kind of attorney stuff, because if it's someone's not honoring a deal and they've sold goods that they are not the owner of, then that's a problem, isn't it? And I would say you could probably get it back, right? If you filed, if you showed, did a report of conveyance on our, and I can get in the weeds, get a little in the weeds on the whole property conveyance, but there's a way that you could probably reattain title to that on our database. But we can talk later. I don't want to, and it's kind of, I'm getting crossing the line a little bit on what really is my purview, but I'm happy to help out. Is there some other questions? Yes, sir.
The engineer comes out, checks it out, and makes his recommendations. Is it the state's responsibility to bring it up to the state's recommendations, or is it on the property owner to bring it up to the engineer's recommendation?
So let me ask you, to clarify, what do you mean by bring it up?
Comply with the recommendations of the engineer.
So I'm not sure I understand. Let me ask it a different way and see if it's what you're asking. So one of my staff comes, you file your claim, my staff comes out and they look at it, and let's say, again, I'm going to keep it easy, 100 acres of irrigation is what you filed your claim on. We come out and we view 100 acres, or we view less than 100 acres.
Or like 240.
You're more than 100 acres. And when we're complaining, you say, well, you got a 100-acre water right, and we'll make that recommendation. But you got to recognize that if you're irrigating more than you have a water right for, you're probably in you are in violation of Utah law, and we aren't going to turn you in, but your neighbors might, and they could probably do an enforcement action. So I'd suggest that you only use water that you have a right for. So if it goes to litigation, so if you're talking about, we make a recommendation for 100 acres and you object to that recommendation, say, no, it should be 240 acres. Is that what you're saying?
Well,
or are you talking about the enforcement action?
We disagree.
If you disagree, you file an objection and then it goes to a judge, right?
Yeah.
Now, it's not a judge paid by us. It's not our judge. It's the Third District Court judge. So it's a separate part of the...
So you still have the right to a trial by jury?
Well, it's not going to be a trial by jury. It's a trial. It's litigation. And I'm no lawyer, so I can't say what. I think there's certain requirements for something to go before a trial by jury, but in essence, it's litigated before the judge. Yeah, and you have due process and all that, but just recognize it's going to be pretty easy for the judge to say, well, you don't have a water right for 240 acres, so. How would you defend that, I guess, is be my question. But yeah, you have the opportunity to try to get that in court. I can tell you right now, it's going to be case dismissed. Your objection is dismissed because there's just zero chance that the court's going to say, well, this guy's really nice and, they rely on this, so let's just give them an extra 140 acres. That just doesn't happen. The judge is going to look at what is your right, what did the state engineer recommend, what are the facts, what's the law, but yeah, you have the opportunity to make your case before the judge, and the judge rules. In this case, it's Judge Laura Scott, Third District Judge. She would make a determination. It'd actually go to what we call the special master. He'd make a recommendation to the judge, and the judge would then review that recommendation. So you have an opportunity to, and then if you appeal that, it goes to the Utah Supreme Court. There's no intermediate, just goes straight to the Supreme Court. All right, any other questions? Yes, ma'am.
So when you're talking about water rights in this certain area of Utah, is there a ratio? Does the state own part of the water rights, or is it just a privately owned that we're talking about?
So our question is there, what does the ownership composition look like of water rights throughout the state of Utah? Does the state own a portion of it, or are these mostly just private entities? You really have a mixed bag. So you have water rights so the state of Utah does own water rights, like the Division of Wildlife Resources. They own water rights for wildlife, right? You have a lot of municipalities that own water rights to provide municipal water. But for the most, and then you have like federal government owns water rights for these big bureau projects, and water users associations, like Provo River Water Users Association own water rights on Deer Creek. The Bureau owns water on Jordanelle, which is actually administered by Central Utah Water Conservancy District. So it's a mixed bag of entities, agencies, and people, private entities, that own these water rights. Did that answer your question, or did I not understand it?
So with that mixed bag, how does it look as usage? Are we over the usage of all water rights now?
Oh, yeah, so good question. So she's asking, and this is how I like to express it, so if we have this much paper water, this is how many rights we have, right? So if you have a bunch of rights for 100 acres of irrigation, and we finally get up to this much, you got 1,000 of those paper rights. How much water do we have? Do we have more water, or do we have less water? By a long shot, we have way more paper water than we have wet water, to answer your question. So the basin is over appropriated, and that's why it's closed to new appropriations. So if you wanted to, you couldn't appropriate a new water right. If you wanted to drill a well, you would have to go buy a water right from someone who already owns one and move it into your well, because it's over appropriated. There's more paper water than wet water. Did that answer your question?
This is what this conjunction is to try to figure out.
Yeah, that's one of the benefits, is that we get a clear vision of what water rights are truly being used. Because as urbanization increases, a lot of these old alfalfa fields are now Walmarts. That water's either gone away, or the water right has not been used, or it's been sold to a municipality. Now it's being used for culinary water. And so it kind of helps the state of Utah define a better picture of the water resources. So that's one benefit. But again, the real reason was to bring all these old claims onto the record, so we really had a complete picture. But it does enhance the picture as well. Is there another question? Yes, sir.
Did I understand you to say that there is a place we can access your slides?
Yes, I'll show it to you here right now. Are there any other questions before I? Yes, sir.
So one last one. So say you have multiple points of diversion in your water rights. It doesn't matter where you're taking that water right from, does it? In other words, where you're drawing that water, if you own the different rights that are part of your water right.
So this question is, if you have one water right with multiple points of diversion, that's the scenario we're talking about. It doesn't really matter if you're taking it from this point of diversion or this point of diversion, as long as you're... Yeah, so we would come out, and really those types of rights are relatively rare, but yeah, in municipalities have those types of rights where they have multiple wells or homeowners associations, and yeah, we're fine with that. As long as you're using the water through one of those points of diversion, we're not going to say that point of diversion is donezo, right? We're not worried about that.
In other words, you might have more rights in one place than the area where you're drawing it, but you're still drawing the water right.
Well, I'm not sure what you're saying there, I guess.
You have the spring and the well and different things like that.
Yeah.
You're drawing more out of your well than you are your
Yeah.
because years go higher.
Yeah. And that happens often. So a lot of municipalities do that, right? They have a spring and then they have a well, because a spring kind of does this and they want that well. And sometimes is historically a spring, then they finally figured, forget this spring stuff, we're going to go to a well so we don't have to treat it. So as long as you're using it from one of those, or one, that's all we're worried about is the beneficial use. And then that it's coming through an authorized point of diversion, obviously. Were there some more questions? Okay, I'm going to check my email really quick, and then just to see if anyone's emailed in a question. And then if not, Paul Gedge has written a test question just to make sure I'm getting it. But no questions. All right. So now I'm going to show you our online interface. I'll show you where to look for these slides tomorrow, as well as the recording. And usually you need to give us maybe a day or two to get this YouTube recording on our website, but I'll show it to you. And also how you can file a claim online. And it's pretty slick, and I'll just show it to you, okay? So I'm just going to go to our website first. Okay, so you can see that, right? So this is our homepage. It's just www.waterrights.utah.gov. So water rights, one word, .utah, spelled out, .gov. All right. So from this webpage, the easiest way to, well, first of all, let's talk about where to find the public meeting stuff, okay? If you look down here, there's a current issues. This talks about prospective meetings. But if you actually go up here, there's a meetings tab. And you see the second one, it says past meetings. You click on that, and it'll just be kind of a list. And you might need to give me a day, because I got to get it to the person to upload it. You click on that, and it'll bring up this. And it's just a big list. So you can see our last one we did, this is a similar type meeting for the Provo North Subdivision. And you'd be able to, I'm going to click on this link to show you what it would look like. So you'd click on the link, and then it would have the agenda, the summons packet, and the presentation slides, as well as the live streaming video presentation, okay? So you just go to One Stop Shop, and you can get all the materials that you've gotten heretofore, okay? Pretty easy. So let's go back to any questions. Do I need to keep this up? You all got it? Okay. Let's go back to the homepage. Let's talk about finding a water right. So let's say you live somewhere in Provo Canyon. You know you have a well, but you don't know what the water right number is just because, hey, you bought this house, you know you have a well, but there was just no discussion over the entire water right number. So, and I'm going to show you how you can find that, as well as you can track the progress of our claim evaluation. So once you file a claim, there's a little interface to show you where it's at in the process, okay? So what you want to do is, see this little button down here? It says Adjudication, okay? I'm used to being, it's usually up here, but our state engineer, Kent Jones, is retiring in this month, and so that's in its place. But you just go to the Adjudication link, and that's going to bring you to this video, which you guys saw, a URL. This is kind of the Adjudication homepage, and what you'll want to do is click on Active Adjudications, okay? It's just that big box. Also, I just want to point out, this is the process, the adjudication process written down in narrative format in case you guys are want to review what the steps are. Okay, so active adjudications. This brings up all the subdivisions that we are actively adjudicating. So imagine what you're doing right now. This is all that we're doing the same thing in all of these different areas. So you remember how I said this is the Provo Canyon 55-9 book? Provo Canyon 55-9, okay? If you want to see what that canyon, what that map looks like, you can hit the map link, and it will show you aerial imagery. It might take a little bit. Let's see how fast this populates. Here we go. So all these purple lines are different subdivisions. You'll note that all these dots, those are all points of diversion, and I can kind of zoom in here a little bit better. All of these are the points of diversion that we're looking at within the subdivision boundary. And so it's kind of hard to see, but this is that north arm of the subdivision boundary. So this is 55-9 area. Our next one will be Midway. We haven't started it yet, but that's where we're going to next. And then you can kind of see the numerical sequence. But these are all the points of diversion that we're looking at within this subdivision. So let's say you kind of live over in the Vivian Park neck of the woods, shall we? And you want to zoom in. You can kind of see these water rights. These are all points of diversion. Now, these are all surface points of diversion. The red ones are underground. The blue ones are surface. The green ones are point to point, so that's usually stock watering. So if you see a green one, those are usually Forest Service rights. I wouldn't worry about them as much. But let's look at this well right over here. Let me click off. So you can actually expand the bubbles, and you can click on it. Now these look like these are exchanges because they have exchange numbers, and I do not want to get into that weed with you guys. So I'm not even going to pursue those any further. Exchanges, you can contract with a Water Users Association or CUP or someone, and they can spill water down the Provo River, and so you could take the same amount of water out of your well. That's kind of the thumbnail sketch of what an exchange is. But let's look at one of these other rights. 55. So let's say this is your cabin lot right here, and you just never knew that you had a water right. And you can click on this. This water right that's the water right number. Its source is 2 unnamed springs. It is filed by Blake Gamble, a surface, and it was a diligence claim. So it's a pre-statutory claim. Now, let's say this is the right you're looking for. You can actually just say, file a water user's claim. You can click on that link, and it'll bring you up to this new interface that we're creating. Hopefully this interface at some point we'll actually be able to file the claim electronically. At this point, all you can do is print off the claim and maybe modify, add yourself as a claimant so it has your name on it. So this interface, really down and dirty, really quick. You start off, so this is for water right 55820, as you can see right there. If you are not Blake Gamble, you can select this other box here, and you can enter in your own information. Okay, you can put in your own name and your own stuff, right? I'm just going to kind of do it really quick. Blake.
Can I ask you a question?
You bet.
So like this guy Blake, he's actually deceased, and his cabin burnt down.
Okay.
So if someone wanted his water right, if he doesn't, or obviously whoever's in charge of his water right, do that process and comply within those 90 days, is that water right then forfeited, like you mentioned previously, it's gone?
Yeah, so his question is, so this Blake Gamble, he's died, his cabin's burnt down, water hasn't been used for over 7 years. What's going to be the status of his water right? Well, probably what will happen is that water right will end up on the list of unclaimed rights and be decreed abandoned because Blake's not alive to file on it. But let's just say, ghost of Blake arises and files a water user's claim, hoping to preserve it. Yeah, we would come out and we say, well, there's no beneficial use associated with this. We'd recommend to the court that it be disallowed. It has a couple of required fields. I'm just going to put my own address. Doesn't matter. And I guess you got that's my cell phone number if you ever want to crank call me. And then you just go down to, you kind of got to scoot over here, hit next, and it'll print a claim form in your name with all the characteristics of that water right, so you don't have to fill out all the other information. So you'll see it has my name, my address, my phone number, my email, and then these are all the facets that water right already had. So this is really the easiest way to file a claim for a water right of record, okay? Well, let's go back to the active adjudications page. I told you there's an interface that allows you to track and monitor the status of your claim. So instead of hitting the map button, you can just hit the actual link, and that brings you to this adjudication progress interface. These are all the rights that we're looking at. They all have water right numbers. These are the owners of record. If you circle down this and you know what water right yours is, you don't want to try to find it on a map, and you know that, hey, my name is Donna LL, and I know my water right number is 55101, you can hit this button right here to file a claim. That takes you back to that same interface I was just at, okay? But again, as what this does is, so you can see this blank box. This corresponds to these colored boxes up in this legend. So right now we've served summons, so all of them are going to look blank. At some point, come October 17th, they're all going to turn orange. And then after that, people will start filing claims. And once we receive a claim, we'll put in the date that the claim was filed, and they may turn yellow. If no claim gets filed, they turn red. Okay? And then those are the rights that are going to end up on the list of unclaimed rights. Eventually, we'll get around, if a claim has been filed, to field reviewing, conducting a field review. Hopefully that's when we call you up and we arrange coordinated date and time to come over and look at your claim and look at your system you got. And then we'll say, all right, it's been field reviewed, and we'll mark it green. And then once we finally come to a recommendation and we've mailed it out to the claimant, it'll become blue. This purple one is for internal use only. That means one of my engineers has reviewed the claim and it's ready to be published in the proposed determination. Really, there shouldn't be, this really doesn't have much meaning to you, because this is where you're looking for. You're looking for your claim to go blue at this point. Are there any questions on this interface at all? Or any questions at all? Sir?
So back to the question that was asked here.
Yeah.
There's some houses in an area, and you're saying rights are going to go to recommend to have them abandoned. Yet there's houses in that area that have been there for 1907 or whatever. Is there any way that the state's interested in helping those people use some of the claims that are maybe already being used, but they're not able to trace those properly, rather than just abandoning them and pulling them out of the canyon?
Yeah, it's not really the state's prerogative. If someone... No, right, I understand what you're saying, and I'm not trying to impugn your integrity or anything like that. So his question was, we have these rights in the canyon, and we're looking at recommending them to be disallowed or abandoned. Does the state have any intention in trying to get these other cabins that don't have water rights, I think that's what you're saying, and shift them over to those entities? So if those cabins have been there prior to 1903 and they've had water usage, then they just file their own claim. It's pretty easy. They don't have to pull one from somewhere else. File their claim and show that it's being beneficially used. That's what this process was intended to do, to bring those onto our records. So they don't need to worry about getting something. Now, if it was built in 1907 or 1945, then they need to go acquire a water right. And the state engineer is not in the business of shifting water rights to uses. We certainly encourage people to go out that and do that on their own, but that's not really...
But somebody can get one transferred up there, even though they're over a lot, they can still get one transferred.
They can buy a water right and hopefully move it up there. Now, it has to go through a change application process. There's an opportunity for people to protest that change. It can be controversial, but yeah, it is possible. I mean, that's how a lot of those houses got water rights up there.
But I heard at the same time that they're not wanting to do that anymore. I've heard of some that have been denied.
That may be the case. And I am not, that's the regional office's wheelhouse. So I can't really speak to the policy. But I think what they may be finding is that I don't know this for fact, that the actual water source that is tributary to the Provo River isn't sufficient to satisfy all the rights that are being moved up into that pocket. I think that, if I recall, generally speaking, that may be an issue. Again, I don't know for sure, though. But we can talk those policy issues. We can go to the regional office and say, what's the issue here? Is that a possibility? What can we tell these claimants that are looking for solutions? And we can facilitate the exploration of those courses of action. And that's what we want to do. We want to help people do that. I don't really have anything else to talk about, but I'm happy to answer any questions of the general public. Let me just check my email one more time. Don't see anything. With that being said, thank you for your attendance. Great questions. We're here to help. I'll stand by. Josh will be here. There's some maps out in the hallway. We'll hang out for a little bit longer. We have about 15 minutes before the rec center kicks us out. So if you want to come ask some questions, happy to field those. Thank you very much.